Thank you, Lilith. So the Executive Office of Housing and Livable Communities, this is the notice on tenant participation. This is a Mass Union webinar. Today is February 25th, 2025. To just give us some background, I'm going to go over the timeline from when we started, when we, you, and Mass Union collectively started this work back in fall of 2023. So the Fall Convention 2023, we had the idea to draft a public housing notice about tenant participation. Tenants met bi-weekly through the Mass Union Policy Committee to discuss this and other matters. Winter of 2024, Megan Hardy, a law student at New England Law School, began working with Annette Duke at the Mass Law Reform and drafted a public housing notice with your input. You then helped to workshop it in several rounds of conversation within the policy committee. June of 2024, we presented a version to Ben Stone, who works at Housing and Livable Communities, and his team. Late summer of 2024, they sent us their feedback, their comments. October in 2024, we sent them new comments in response. So there was a back and forth during that time. And then in December of 2024, they issued the public housing notice. So this was this whole process took over a year and demonstrated how when we collaborate with each other and our voices are heard. And our voices were heard, and now we have this public housing notice that Annette is going to go through by giving us both high-level detail around all of the sort of meat and potatoes of the public housing notice and where you can plug in.
Good.
Again, if you're not muted, please mute yourself so we can have the presentation and not have disruption. So with that said, I'm going to turn it over to Annette. She is a brilliant legal mind, award-winning community organizer and legal advocate to walk us through the fine details of this public housing notice. So Annette?
Thank you, Maria. It's great to be in the room with resident leaders. We worked hard on this notice and it is an important accomplishment, but now we have to use it. It's a tool. And so the purpose of this webinar is to go through and highlight some of what's in the notice. So it was in December of 2024 that the Executive Office of Housing and Livable Communities, which we say for short HLC, because it's a mouthful, issued this public housing notice at our request. It builds on the state regulations, the participation regulations, which I know you're all familiar with. I know you have them on your kitchen table. You look at them all the time. The PHN notice it was the last one in 2024. So it says PHN 2024-2025, and that's the picture of it. That's what it looks like. It's an official notice. And so I think Lilith is going to put that link in the chat so you can see it. Maria, do you want to do next slide? Oops. There we go. So it starts off with what the benefits of tenant participation are. You know more than anything why tenant participation is important. I know you also face hurdles, which is why we do this PHN, but it reaffirms that the participation of residents through local tenant organizations and through LHA boards benefits public housing and the quality of residents' lives. The PHN states, and for the slides, the way I structured these slides was I always put what the PHN, the public housing notice, states in quotes, because that's important language for you to use if you ever communicate with a housing authority in writing, is to quote the PHN. So the PHN states that the Executive Office of Housing and Livable Community Regulation and Guidance detail areas that must involve residents. I underline the must because must is a requirement. It's mandatory. This is not negotiable. And again, it builds off of what the regulations provide. Next slide, Maria. And so When must the LHAs involve residents? So the PHN clarifies and restates that LHAs must allow residents to participate in the hiring of an executive director, in the hiring of staff who have direct dealings with residents, like resident coordinators, if there's a new management agreement or a merger with another housing authority, when there's redevelopment and modernization, residents must be involved and have a space during the LHA board meetings. You must develop policies with the housing authority that impact residents. Residents must be involved in the yearly budget and the annual plan, and also the capital improvement plan. So those are all the places where residents must be involved. Next slide, Maria. So how must housing authorities support and encourage LTOs to form? The LHAs can give resident contact information about Mass Union so that Mass Union can actually provide election and tenant participation support. The PHN actually includes a sample notice with Mass Union contact information that's translated into 6 languages. It's called Attachment A. It's at the end of the notice. It's a really important piece of paper. It's the first time I've ever seen something like this in a PHN notice, where their housing authorities get a notice that provides them with contact information that they need to give to residents so that residents can contact Mass Union, so that Mass Union can support residents to create LTOs and to get involved. So ask your LHA to distribute Attachment A to all residents. Very important. Next slide. So some opportunities for housing authorities to support LTOs. The PHN clarifies that if residents request, that's important language, if residents request, the LHA can, in terms of elections, mail or deliver election materials to all residents, remind residents to participate in elections through robocalls and emails, translate election materials provided by residents, and allow resident service coordinators to assist in the coordination of elections, because elections take a lot of time. You want a lot of participation. And so these are all the ways that the LHA can support the development of LTOs. There are other things in the notice. I just pulled out these 4, but the PHN importantly also clarifies that the election materials should not be written by LHA staff. You won't find that in regulations. This is where the PHN actually builds on the regulations. So it clarifies the housing authority can't write election materials. The residents need to, and Mass Union has a lot of that, so you don't have to reinvent the wheel. We've got it. Maria, next slide. LTOs should control their own affairs and not be controlled. So the PHN states very clearly that once residents democratically elect officers to represent them on matters that impact them, the organization should be treated as independent of the housing authority and autonomous, and not as an extension of the LHA. I know many of you feel this way, but this language is important because sometimes the housing authority does not treat residents as independent, but they treat residents as an extension of the housing authority. You are independent. The PHN also states that an LTO should have the freedom to govern itself, develop its own budget in compliance with HLC's budget guidelines, develop its own bylaws, and control its own affairs. This is language, again, you won't find in the regulations. It's in the PHN notice. And it's really an important principle that you need to put on the table with the housing authority when you meet them, that you are independent and that you need to control your own affairs. Maria, next slide, thank you. Negotiating an agreement on LTO participation. So the regulations already provide that, the LHAs and the LTOs must negotiate an agreement in writing related to tenant participation. Sometimes those are called memorandums of agreement, memorandums of understanding. Mass Union has a whole booklet about that. But the PHN states that should an LHA fail to negotiate in good faith or refuse to negotiate an agreement with LTO, the LTO may communicate its objection or to to the LHA board, and the LHA board shall consider such objection or concern in determining its action on the matter. So the PHN reminds LTOs and LHAs also to date the agreement to assure that you're all working off the most current version. That's a detail. But this language that if an LHA fails to negotiate is really important because, again, it's not as clear in the regulations. And what HLC did was try to clarify that the LTOs can start to go up the chain of command if the housing authority refuses to negotiate an MOU with you. And that one of the first places is the LHA board. I'm going to say this later on, but anytime that you raise an objection, you should do it in writing. It protects you, it protects the LTO, it protects everyone. So make sure that you're putting all of what's happening in writing. Maria, next slide. Communications and meetings. So the LHA should schedule meetings with the LTO at least quarterly at a time and place reasonable for all parties, but you can meet more frequently to strengthen that communication. The regulations provide the quarterly. Many of the organizations we know actually put in their memorandum of understanding that they meet every month. That's great. At least one of these meetings has to review a draft annual plan. What the PHN states, and again, building off the regulations, is the review in its draft form allows the LHA to consider the LTO's input regarding needs and priorities for inclusion in the plan and make changes if appropriate. So what this does is it clarifies you don't get the plan after the hearing, after they've gone through, a process, or even just before, but that you should get a draft plan so you can have input so that the housing authority can make changes based on what you identified the needs and priorities as. Again, these words are important. And when you frame what you want, you should say, these are our needs and these are our priorities. And as an LTO, and Mass Union has courses and teaches you about how to set priorities as a group. That's your strength, is as a group to set priorities and to bring those priorities into the annual plan process at the draft stage. Next, please. What if the LHA fails to schedule meetings? So the PHN states, should the executive director or its designee regularly fail to schedule or appear at such meetings, the LTO should communicate its concern to the executive director, and if unresolved, may raise the concern to the LHA board in writing, and the LHA board shall consider such objection or concern in determining its action on the matter. Again, put your concerns in writing, otherwise there's no proof you've raised the concern. And again, you're going up the chain of command. And even though it's the executive director who failed to appear, you need to communicate with the executive director first that they need to meet with you regularly. And if you don't get any satisfaction out of that, this PHN says you can bring it to the board. And if you don't get any satisfaction there, Mass Union can help you bring it to HLC. Okay, next slide. LTO space with privacy to operate independently. Again, independently. So upon request from an LTO, the LHA must provide an LTO with a reasonable amount of space for use as an office. The LHAs will consider the reasonableness of the request, of course, with consideration of cost and availability of space, which sometimes is limited. The PHN states and clarifies that while the space may be shared, it must offer the LTO privacy to conduct its business and operate independently. And so, again, the space may be limited. If a housing authority puts you into their space, you still need privacy to conduct your business and to operate independently. And the notice states this. Next slide, please. Getting tenant participation funding. All right, this was a huge victory last year for Mass Union. LHAs must fund the LTOs at a yearly rate of $25 per state public housing unit occupied or available for occupancy. To receive the state LTO funding, an LTO must, 1, adopt an annual budget with your members. 2, submit the adopted budget for approval from the LHA. 3, submit a year-end financial statement approved by the LTO. And 4, make the year-end financial statement available to your members. Again, this is part of this is about you're being accountable to your members, and you're being financially accountable to the Housing Authority on how the money is being spent. Next slide, please. What can the tenant participation be used for? So this is where the PHN really tried to clarify questions that were being raised about what the state funds can be spent on and what they can't. For example, tenant participation funds can be spent to buy light refreshments for meetings, but they can't be spent on parties that are only social in nature. Tenant participation funds can be spent on conferences and training expenses, like mass union conventions, but can't be spent if the purpose of the event is only amusement or social. In the PHN notice, there is attachment B. Print that attachment B out and put that in your LTO office. Make sure all the officers have that. That articulates what expenses are allowed and what aren't. And you just need to keep reviewing that and make sure you're staying straight with that. Next slide, please. So what happens if the LHA fails to release funding? If the LHA staff fail to release LTO funding in a timely manner, the LTO may, again, in writing, communicate an objection or concern to the LHA board, and the LHA board must consider this objection and concern in determining the action on the matter. So again, 2 things. You put it in writing and you're starting to go up the chain of command. But the PHN does one better. It states if the LHA continues to delay the release of funding after you go up the chain of command, the LTO may elevate the objection or concern to the Executive Office of Housing and Livable Communities in writing. And the Executive Office of Housing and Livable Communities will determine next steps to resolve the issue. So you need to put it in writing. You can go up the chain of command, Executive Director, Board, and then HLC. Next slide, please. Additional equipment for LTOs. So the regulations, the tenant participation regulations are 760 CMR 6.09. 3E requires the LHA to reimburse LTOs for basic in-state telephone calls related to LTO business. The PHN states an LHA may negotiate with an LTO to supply additional equipment to the LTO, such as computer, Wi-Fi, internet, a lockable cabinet, or access to printer and copy. These were all things that you suggested. The PHN also states that the Executive Office of Housing and Livable Communities encourages LHAs to support LTOs to secure internet services to enable LTOs to access information and materials online, all the notices, the policies, and approved plans, proposed and approved plans on the LHA's website. So you need to negotiate that, but this notice says that HLC encourages LHAs to do this. And the way you can use this notice is to bring this to a meeting with the LHA and say, HLC encourages this and we'd like to negotiate this with you. Next slide, please. Resolving conflicts. How many people have conflicts with the Housing Authority? Can we just see a show of hands? Your natural hand. Any conflicts? Okay, I see a couple. So the PHN states communication between the LHAs and the LTOs should be respectful and inclusive of differences of perspective and opinion. I realize these are just words. And it's okay to disagree, but on both sides of the aisle, the disagreement has to be constructive and respectful. And the PHN clarifies that there are resources available through mass union and community mediators to help work through conflict if the conflict continues and it's not productive and it's not constructive and it's not respectful. Next slide, please. The LHA must follow specific excuse me, just a second. LHA must follow specific procedures to request the Executive Office of Housing and Livable Communities to revoke LTO recognition. In other words, the Housing Authority just can't revoke your recognition. They have to go up the chain of command too. And there's a specific process. And so the PHN states in rare circumstances, there may be a need to consider revoking the recognition of an LTO. The LHAs must initiate the revocation with a written warning to the LTOs, which specifies the reason in detail. So you know why, what's the reason, and that you have written notice, and it's a warning. The warning must also include a description of what steps the LTO can take to cure or fix the alleged violation. In other words, the Housing Authority just can't say, we're revoking your recognition. They need to give you a chance to correct what you've done wrong. It should not be punitive. I know that that's not always the case. The cure or the fix has to be reasonable to enable the LTO to remedy the problem before the request goes to the Executive Office of Livable Communities, so that you know what steps specifically you can take to fix the problem, if there is a problem. Next step, please. Slide. Only HLC can revoke LTO recognition. Just keep remembering that. If the LHA makes a revocation request to HLC, the Housing Authority has to send a copy of the request, it's a request, to the LTO at the same time. The LTO has 30 business days to file a written opposition to the Executive Office of Housing and Livable Communities. The notice states that the Housing and Livable Communities must schedule a hearing at the LHA, at which the LHA and the LTO shall be required to appear and submit evidence in support of their positions. And so there is this process. As this process is pending, as a revocation decision is pending at HLC, however, an LTO must continue to be consulted. That's what the PHN states. Only HLC, again, can revoke LTO recognition, and these procedures have to be followed. And HLC doesn't have to revoke your recognition. They could do a lesser sanction if they deem appropriate. They can say you need to fix this in order to keep your recognition. Next slide, please. How to use this PHN. So if you have an LTO and the LTO did not receive this PHN, sent from the Housing Authority, send your LHA a copy so they know that you are aware of this, and ask them to meet. Ask to meet with the Executive Director to review it. You can share with them this PowerPoint. That's fine. Make the request in writing and use this as a step to try and improve communications if communications are not good. If you do not have an LTO, ask the LHA to give all residents Attachment A, which has contact information for Mass Union, so Mass Union can come in and help you form an LTO and help you conduct elections and get that started. Next slide, please. What if your LHA does not follow this PHN? So I've said this several times, but we have to just keep reminding ourselves, if the LHA is not following this PHN, raise your concerns in writing and move up the chain of command. Start with the Executive Director. This is how you are not following this PHN. If the Executive Director doesn't change anything, go to the Housing Authority Board, again in writing. If the Housing Authority Board doesn't give you satisfaction, next go to your Housing Management Specialist at the Executive Office of Housing and Livable Communities. The notice recognizes that HLC values the perspective and insights that residents bring to LHA management of its properties. These are important words because you have to hold everyone to them. It's your actions that will hold everyone to them. It's not the words alone. The PHN also states that if you have additional questions about working together with residents or LTOs, contact your housing management specialist at the Executive Office of Housing and Livable Communities. Again, this is what the notice states. and we have to use the notice. And if things start to go wrong, you need to contact the housing management specialist after you've gone up the chain of command. And you're going to need to show the housing specialist all the ways that you put things in writing. So keep all those written documents together. The one that you sent the housing authority saying, you did not follow this part of the notice. You did not follow this regulation. Keep that in a folder. Print out a copy. Then keep the same thing that you did with the board. And then if you have to go to HLC, you'll have all of these things in writing to show them about what efforts you made. Next slide, please. So
Right.
Mass Union's values, this is where Maria is gonna take over.
Thank you, Annette. So the root of all of this work that we did for over a year with the Executive Office of Housing and Livable Streets is our values. And they're stated on our website, and you may have seen them. But two of the values that we would like to amplify for this discussion is tenant power and unity. Power should be with the people, and that is you, the tenants. That is key to everything that we do. And unity, once we've reached a group decision, it's respected by all, and we speak with one voice. We don't have to be best friends, but we understand that in order to win, we need each other. So we prioritized and centered these two values in this year-long process with the Office of Housing and Livable Communities. And we are proud of that, of leading with our values and of co-creating and collaborating with you all. So we just want to say spaghetti power, spaghetti power, spaghetti power. That is what we did and what we will continue to do as we work on other efforts with the Executive Office of Housing and Livable Communities. So I'm gonna stop there because that is the extent of the content that we want to share with you.